Hi, everyone. Thank you for being here, everybody in class and on Zoom. Really appreciate you taking the time to be with us today. I'm really looking forward to this talk. I'm here to talk to you a little bit about the Institute for Liberal Studies. I'm the Educational Programs Manager there. And we put on talks like this one on campuses all across Canada. I think we've done every province except for PEI, and I'm working on it. So we're doing that as much as we can to get interesting speakers, interesting topics into classrooms for students to listen to those ideas and interact with them as much as we can. We also put on a lot of other programming that would interest you, including a summer fellowship program, which we just finished searching for some summer fellows recently. You're more than welcome to apply next year, where we place students at organizations, public policy and educational organizations across Canada for them to work in the summer and interact with the Institute for Liberal Studies throughout that as well. One thing I want to talk to you about that you can apply for still is Freedom Week. It's coming up in the summer, August 11 to 17. It's at McGill University. We cover all costs except for travel. So you spend a week. You're all students who are interested in coming to a talk that you do not get credit for. So those are the kinds of people who love to have a Freedom Week. You don't get any credit. It's just there for you to interact with ideas and to hear from speakers. We have 5 amazing faculty members from Canada and the United States that come and talk to you about ideas about law, economics, public policy, philosophy. And you get to interact with those ideas not just as a lecture, but you have the opportunity to ask questions, but you also get to interact with these professors at meals, at hospitality. Like, it's just a great week to really engage with ideas and with people who have them, and with your colleagues, with other students as well, and form those relationships with people that are a lot like you, who just really are interested in learning. It's at McGill University. It's in the summer. It's a lovely time. It's one of my favorite things that we do. And I'd love to get some applications from some of you today from UBC. I'd love to see some of you there. And you can apply at www.liberalstudies.ca/freedom-week. Application deadline is April 28th, and we do not extend it. So please apply before then. Really looking forward to this talk. If you have any other questions before I get into that, if you have any questions about any of these things, please come and talk to me. If you're online and you have questions, just take a look at our website. My email is on there. I'd love to talk with you. Really looking forward to this talk. I'm going to hand it over to Kim Richardson to introduce the speaker and get us going.
Okay. Thank you. So welcome everyone to this exciting talk. Who gets the benefit of corporate decisions? Does it matter what courts and regulators say? Presented by the Center for Business Law and co-sponsored by the Institute for Liberal Studies. So this should be a really interesting talk on a subject that I am personally very interested in. So I'm sure that I will have some questions for Professor Tingle myself. That said, allow me to introduce our guest speaker. Bryce Tingle, King's Counsel, is the N. Murray Edwards Chair in Business Law at the University of Calgary. He is a director of several companies active in the technology and financial industries, and has also served as the general counsel of several technology and natural resource companies. From 1994 to 2006, prior to his academic career, I assume, Professor Tingle was a co-founder and partner at Tingle Merritt LLP, focused on securities and corporate finance for growth companies. Professor Tingle is currently a member of the Alberta Securities Commission. He is also a member of the National Special Advisory Group to the RCMP's Integrated Market Enforcement Team. He previously served on the Exempt Markets Committee of the Ontario Securities Commission and on the Securities Advisory Committee of the Alberta Securities Commission. So truly an expert on corporate and securities matters. Before we get started, I'd like to thank Sabine and the Institute for Liberal Studies for helping put this event together. With all that out of the way, we might as well go ahead and get started. So Professor Tingle, please come up here and take it away.
Thank you very much. Thank you, Ken. Very kind. I'm very pleased to be here with you today. And I want to start by talking just briefly about corporate governance. The first thing I'm going to say is, to the extent any of the students here think they want to do corporate law, you will find yourself eventually engaged in corporate governance. The people who hire corporate lawyers are generally the people who occupy the C-suite, people like this CEO and CFO, the general counsel. And they spend their time, like all of us, worrying about their bosses. That is, they don't spend their time staying up at night worrying about the employees. They don't spend their time worrying about usually creditors, customers. What really worry them are the board of directors and shareholders. And so eventually, as you become, as your career develops, you find yourself spending more and more time on corporate governance issues. So it's worrying about shareholders and directors. Is everyone familiar with the way a corporation works? I don't want to, I would like to be able to claim that someone else did this, but it was in fact me, and I was doing my very best. But I drew sort of how a corporation looks like. You've got a corporation, and it's got a lot of different constituencies that are needed to be brought together for the corporation to do whatever its job is. So you need employees, you need people who extend the company credit, you need customers, you need the communities that operate, you need suppliers. You need all these groups to come together, to coordinate their activities, to actually produce the goods and services the corporation is going to use. All of that sort of coordinating this productive coalition, as economists call it, are a group of managers. Periodically in the class, I'm going to just refer to the CEO. Practically speaking, a senior manager usually consists of 3 or 4 people in a company. And which 3 or 4 kind of depends on the company and the personalities involved, but almost always includes the CEO and CFO. I'll probably just use CEO as a shorthand. The CEO reports to the board of directors. If you've read the corporation statute, you know that the board of directors actually have all the power there is in the corporation. They only delegate some of their power to the CEO. Now, the actual relationship, they also are responsible for hiring or firing the CEO, which they typically do at any time. The actual relationship in terms of power between the CEO and the board of directors is an academically highly contested matter. But the fact is, there is some relationship, and if it ever gets into a breakdown fight, the board of directors always wins. And then at the level above the directors in turn are elected by the shareholders. So that's the overall structure. I just wanted to get that out because sometimes when I teach law students, they have, even if they've taken business associations, they have gratefully forgotten it by the time I guess. So the most important duty in corporate law is the fiduciary duty. It's the central duty of corporate law. It's the duty that says directors have to act in the best interest of the corporation. But the question is, what is the best interest of the corporation? Because obviously corporations are figments of our imagination. So it can't announce to us what its best interests are. And there's been a perennial dispute about what those interests consist of. I'm going to say the dominant view for most of Canadian legal history has been that the duty of the directors and officers of the company, the fiduciary duty, consists of maximizing the company's profits. That is, competing maximally successfully in the markets in which the corporation participates. Periodically, and this is not a new debate, by the way, I think we're at an upswing in the debate, but periodically over the last 150 years since we kind of invented the modern business corporation, there has been people saying, no, there's the directors have other duties. They also are supposed to maximize or improve outcomes for employees, even if that might interfere with the outcomes that are received by shareholders or other groups. They have to look out for the environment. They have to look out for the customers, the business partners they have. They should be looking out for the communities in which they operate and on which they depend. And they need to be looking out for the environment because the environment, obviously, they depend on the same way we all depend on our environment. We are currently living in a moment when there's been a considerable amount of effort put into, in particular, 2 things. The hope has been that if we can somehow encourage companies to do better than they have in relation to diversity questions and in relation to the environment, particularly carbon emissions. Nevertheless, while those are two kind of relatively new initiatives, they fall into a well-worn path of saying, look, it's not just maximizing profits, it's looking out for the other constituencies that form around the corporation. Typically, the way of saying this is that there's been a debate in corporate law between those who feel the duty of the directors is owed, and that is the purpose of the corporation, is to maximize shareholder value or to maximize the outcome for stakeholders or constituencies. Two terms that mean essentially the same thing in the debate. The reason why shareholders are pitted against every other constituency is because in the corporation, shareholders are the residuary interest holder. That is, they get paid when only after everybody else gets paid. Now, there are problems with American bankruptcy law. That means private equity funds very famously figured out ways to get paid before other creditors get paid. But in Canada, it's a pretty solid rule of thumb that shareholders don't get anything. But don't worry about it. Now I know how terrible it is for you, I guess. That's a moment of real empathy for me. Anyways, because shareholders are the last ones to get paid, the assumption always was, well, that makes sense, right? If the shareholders are getting paid, then the employees are getting what they need, the customers are obviously being served well, the suppliers are getting what they need, the creditors are getting paid off. We should be the shareholders. If you just focus on the shareholders, everyone else is being taken care of. And this is precisely what has come under attack. The biggest debates right now at this moment in the world of securities law and corporate law are specifically around this. So the CSA is just about to announce its carbon disclosure rules for comment. I expect we're a month away from that. The SEC, 2 weeks ago, 10 days ago, announced the US carbon disclosure rules. The diversity disclosure rules, which is designed to improve board and executive diversity, the CSA put out a request for comment in May of last year. It received comments. In fact, we received a lot of comments. And it will put out some final rulemaking materials on it, again, probably in the next couple of months. There are amendments to the Corporations Act, the Federal Corporations Act, that also touch upon diversity. Say-on-paid voting, which is a rule of the TMX, is now much discussed. The Securities Commission is thinking about interfering with that rule, the way it's operated. That is also sort of a current debate. So what I want to say is I'm not talking to you today about something that is of only sort of dull scholarship interest. This is what corporate lawyers and regulators are currently thinking about. Okay. There's one other factor that I want to introduce as I set up the debate. And that is, it has been the overwhelming assumption in corporate law scholarship and in corporate law regulation for the last all 45 years that the best way to understand the problems of corporate governance are that managers and CEOs have control of property that isn't theirs. And that they're in the position, therefore, of being able to expropriate property that really belongs to the shareholders. This worry goes under the term agency cost. And it's not really a theory, it's called agency cost theory, but it almost never rises to the level of a formal theory. It's more of a story we tell ourselves, that managers are prone to dipping their hands into the cookie jar, and that the board of directors, to a more limited extent, the shareholders' job is to slap that hand when it goes into the cookie jar. And how do managers do this? They do this by paying themselves more than they're worth, or spending money on corporate jets or other perquisites, or slacking, taking a brief vacation, or negligence, making dumb decisions because they can't be bothered to spend the time and effort it takes to make good decisions. So we've had as our major focus, I would say the dominant focus the last 40, 50 years in law reform and other initiatives, we've had our focus being, let's reduce agency costs as low as possible. The costs the shareholders must bear of paying their agents to manage the shareholders' property. That's the whole goal. This view of corporate governance got fastened on to a much older question of who runs, for what purpose does a corporation run. And it got fastened on to that old debate, which, as I said, has been around as long as, for the last 150 years. In this way, people started saying, look, the only way to hold management actually responsible for what they do is to have a clear goal for management. We make it very clear you have one job, that's to in most cases, the argument is it's to maximize shareholder welfare. And because we've got one simple goal, it's very easy to figure out if management is slacking on the job. It's very easy to go after them if we think they're diverting too much money to employees or to managers or to other purposes, for corporate charity, or to any other way that the corporation's property might be, quote unquote, misused. And so the argument has been, we have to believe in shareholder primacy. We have to believe the shareholder wealth maximization or profit making is the only purpose of the corporation. Because if we say, no, the purpose of the corporation is to do a bunch of other things, like care about the environment, take care of employees and the communities, we've suddenly given management a whole bunch of goals, and we cannot hold them responsible for any of them. The frequent way of saying this is a duty to everybody is a duty to nobody. And that seems to me about right. So this has been the debate that has been going on recently. Okay. In the course of this talk, and when should I be done?
So we've got a full hour left. So, I mean, maybe leave 20, 15 minutes for questions.
Okay. All right. So in the time we've got left, I want to talk about, I'm going to try and make the following case. I'm going to make the case that the shareholders, regardless of what we would like, and really, regardless of what we like, I mean, we're not monsters here. We all think the environment is important. We all think employees are important. We all think paying out creditors is important. But regardless of what we like, I'm going to argue the shareholders are always going to win. The second thing I'm going to argue is that the assumptions behind our debate are stupid. And the third thing I'm going to argue is that the Supreme Court accidentally, it's almost the only way the Supreme Court accomplishes anything good, the Supreme Court has accidentally proved my case for me. So that's the argument. I'm going to start with the most important corporate law case of my lifetime. And that is the decision of, in 2008, BCE versus 1976 Debentureholders. Can I just show of hands familiar with the case? Okay, I'll explain the case. All right, so the bottom line, which you need to keep in mind as I describe the case, is the Supreme Court told us for the first time the duty of directors and officers of the company, this fiduciary duty that is at the center of corporate law, and that defines the purpose of the corporation. That duty is not to maximize shareholder value. It is, in fact, to take into account all of the interests of the corporation in some way that is under-theorized. It's not clear exactly how you do that. I'll come to that in a second. But it moved us from what corporate lawyers call a shareholder primacy jurisdiction, where shareholders are the most important thing, the main focus, the only focus, to a constituency or stakeholder jurisdiction. So this is what we see. That's why it's so important. Okay. Here are the facts of BCE. BCE, which is a giant telecommunications company, agreed to a leveraged buyout. That means the people buying BCE didn't have the money lying around, so they had to borrow a bunch of money. And when you borrow money for a house, you take out a mortgage. When you borrow money for a company, you do the same thing, which is you take out debt against the assets of the company. So it's a leveraged buyout. There was an auction process. run by the board of directors, and the whole purpose of the auction was to attract the very highest bid to maximize the amount of money the shareholders received. The directors knew without being told that was their job. I'm old enough to advise boards of directors. That's what I would have told them. That is what their lawyers in Toronto told them. The winning bid was a 40% premium over market, which is outstanding. Good work on the directors, right? High fives all around. Unfortunately, because the premium was so high, that meant the amount of debt that the successful bidder had to apply was also very high. Remember, that debt is not going against the bidder's assets, it's going against BCE's assets. The effect of this then was that there was a class of debentures that were issued in 1976. This is the 1976 debentures in the title. And debentures is just a fancy word for a debt instrument. So people would loan the company's money, and then these debentures traded back and forth. So the 1976 debentures were unsecured, and the application of all this debt ahead of them meant that their value went way down. In fact, there were claims they would lose their investment grade credit rating, which is like falling off a cliff if you're a Dow. It's fine if you're buying junk and you know you're buying junk, but have debt that you bought thinking it was investment grade that suddenly becomes junk, that is an apocalypse in terms of the value of your asset. So, what did the board of directors know and think about the debenture holders? They knew that the debenture holders were going to get screwed. They kind of designed the deal to get screwed. And in fact, they made a change to the structure of the deal because they knew that if they actually let the debenture holders have a say on this deal, the shareholders would vote, the debenture holders would vote no. So they actually structured the deal so it could be done without the debenture holders getting a say in it. So the debenture holders got very upset and sued, and we find ourselves on the Supreme Court. So what can you say about the Supreme Court decision? The first thing is, like virtually every other Supreme Court decision on the corporate law topic, it's not very good. In terms of being bad, here are some of the ways in which the Supreme Court is bad. First of all, it's badly written, number one. So in one place in the decision, the Supreme Court says the director's duty to consider stakeholder interest is discretionary. I'll read this quote. In People's Department Stores, which is another dumb case the Supreme Court wrote, this court found that although directors must consider the best interests of the corporation, which is saying nothing at all because as you described, corporations are fiction, so who knows what their interests are, must consider the best interests of the corporation, it may also be appropriate, though not mandatory, to consider the impact of corporate decisions on shareholders or particular groups of stakeholders. Okay, that sounds like the directors have the discretion to pick who they're going to benefit in the course of their duties. Then elsewhere in the decision, the Supreme Court says, actually, no, the duty is mandatory. Quote, the duty of the directors to act in the best interest of the corporation comprehends a duty, which is mandatory language, to treat individual stakeholders affected by corporate actions equitably and fairly. And then they also say something which sort of sounds like it's either mandatory or discretionary. Listen to this sentence, and imagine that your job is to advise the board of directors based on this dumb sentence. Directors may be obliged to consider the impact of the decision on corporate stakeholders. It would take a once-in-a-generation philosophical genius to parse the relationship of may, oblige, and consider to determine what the Supreme Court is trying to tell us to do. So that's the first problem with BCE, badly written. The second problem with BCE is it didn't reflect the case law. At least 17 decisions from courts across Canada held that the fiduciary duty is ultimately owed to the shareholders. That doesn't sound like a lot, but for Canadian corporate law, that is probably the single largest corpus of precedent on any subject. And we find that the Supreme Court said, we're the Supreme Court who fired pistols up in the air and said, we're just overruling all this precedent. But the Supreme Court pretended that they were actually following precedent. But just so that we're clear, they're lying. That wasn't the precedent. To give you an idea of how little the Supreme Court's pivot in BCE to a stakeholder conception of fiduciary duty mattered to courts. None of the earlier BCE decisions, as it made its way out through trial to the Provincial Court of Appeal, referenced anything other than shareholder maximization. It just hadn't occurred to any court that this was not the law of the land. In fact, the Supreme Court had actually itself advanced the shareholder primacy position as recently as 1997, so about 11 years before the BCE decision. The Supreme Court was only able to adduce two authorities for the proposition. I will get into the details if people are interested. It's inside baseball. Bottom line is, they weren't particularly good authorities. One of them came from this province, it's particularly bad authority, though don't take that personally. It just happened to even the best of provinces. Okay, you might go, all right, so the decision's badly written and it doesn't follow precedent. And the precedent it claims to follow doesn't say what it does, and it contradicts the Supreme Court itself. Maybe at least the decision itself, just in the context of its facts, can help us. Here's the most important thing to know about BCE. The board of directors got off scot-free. The Supreme Court, now keep in mind, this is a board of directors that had done everything they could to maximize the value for the shareholders, and had done so by going out of their way to screw the debenture holders. And they knew it. I assume they laughed and rubbed their hands as they discussed how they were going to screw the debenture holders. And the Supreme Court said, you know what? You considered the interests of the debenture holders. What? So keep in mind, our goal is to screw the debenture holders. That's enough for the Supreme Court. You turned your mind to the debenture holders. Wow, a duty like that, who needs enemies, right? I mean, anyways. So corporate lawyers greeted BCE with, I was still in practice at this time. I was general counsel of a very large company. And our attitude was, well, this is just garbage. I don't know what to do with this. But the good news is, because it does sort of say that you've got a duty to everybody, I guess that means you've got a duty to nobody. Like, if you can get off scot-free when you're sued by the debenture holders, and the Supreme Court says, well, it's enough that you turn your mind to screwing the debenture holders, you've done your duty to them. Okay, that's great, right? From my standpoint, from the standpoint of people who are in the boardroom, couldn't ask for a better case than that. So most of us have moved on. All right. Any questions about BCE? Online, if they've got questions. Okay, good. So about 3 or 4 years ago, I got interested in the question. What happened because of BCE? This is the single biggest change that's happened in my adult life. Canada moved from a shareholder primacy jurisdiction to a stakeholder jurisdiction. Now keep in mind, there's this giant argument that maybe we can transform the world by caring about stakeholders instead of those nasty shareholders and their obsession with profits and share value. So I wanted to find out, what evidence do we have that things changed after BCE? So here's what I found. This all comes from a paper that was published in 2019. BCE's alteration of a fiduciary duty has never produced a litigation outcome, ever, in the first 10 years after BCE. So what would it take for BCE to produce a litigation outcome? One, you'd have to have a case where directors said, we are all in on shareholders, and successfully were sued by, say, the employees or the community, the town in Ontario that they operate in. That's never happened. The second way it could drive a decision is if the shareholders sued the directors and said, you screwed us, and the directors used as a defense, we did, but we were actually acting in the best interest of the employees or the best interest of the community. Or at one point, by the way, the Supreme Court actually says the best interest of the taxing authority. I say that to American law professors and their jaw drops. Right? It's Canada. You do have a duty to the taxing authority. Anyways, so the first thing is its effect on the case law is zero. The second thing is After the BCE decision, I wanted to see what happened to takeover premiums. The whole reason BCE got into trouble, the board at BCE got into trouble is they worked hard to maximize the amount of money going to the shareholders to jack the premium up to 40%, and that screwed over the debt holders. So we would expect, if the Supreme Court had any impact at all, we would see a decline in takeover premiums in Canada over the decade. So I worked out what the trend was before BCE, and I worked out the trend from the 10 years after BCE. And what I found was exactly the opposite of what you'd expect if you took BCE seriously, which is takeover premiums in Canada increased in the 10 years after BCE. That is, as far as we can see, managers were bargaining harder for, on behalf of the shareholders. I then looked at some of the common measurements to see, were the shareholders worried that they no longer were number one in the minds of the directors? Were they worried that value might be diverted to other constituencies? And so you'd expect to see that in the equity value of corporate assets. That is the price that shareholders are prepared to pay for corporate assets. The standard measure of this is something called Tobin's Q. Details unimportant. But what I found was the equity value of assets went up, the exact opposite of what you'd expect. I then looked at the equity value of corporate cash flows and found that contrary to what you'd expect, that's the earnings per share number, earnings per share went up. I then looked at the discount corporations had to offer to induce new investors to buy their stock. This is most financings are conducted at a discount to the market price. The market price is the price at which trades are clearing. So if you need new investors to come in and buy stock, you've got to give them a bit of a discount from market price. And I found that the discount was narrow. In other words, every single thing you could measure that you'd expect to change because of BCE went in the exact opposite direction. It appears that the Supreme Court of Canada, its most consequential decision in Canadian corporate law, let's say history in the last 50 years, had no effect on what was going on in Canada's board. And it shows that the shareholders are unsurprised. The shareholders never worried that their interests would start being disregarded by people who are now caring about the environment and employees instead. If the shareholders had worried, we would have seen a decline in earnings per share and Tobin's Q numbers, but we didn't. Now, I want to caveat this. There's an obvious problem with this research, which is we don't have controls. Life doesn't always give us controls, and we're stuck with the best data we've got. So it might be possible that BCE did have an effect. The effect was, yeah, takeover premiums continue to go up, but they would have gone up by a lot more, or by at least some more, if it hadn't been for BCE. And we'll never know the answer to that question. But it seems unlikely. Most of you, too young, but Canada's public markets were a very happy place in the run-up to BCE. Right up until the financial crisis, the world was in what we call a commodity supercycle. As China started industrializing, as India and Brazil and some other parts of the world started getting richer, the stuff that Canadian companies make became incredibly more valuable. Oil, minerals, our agriculture, and the prices for these commodities went through the roof. So since BCE, we have had an outright recession in the oil patch and very flat times periodically for things like mining and agriculture. The world economy has never been firing as many cylinders as it was for the 5 years, 6 years before the financial crisis. So just common sense would tell you that if takeover premiums are still increasing after BCE, it's unlikely that they would have been increasing even more. There were heavy headwinds again in post-BCE and great tailwinds pre-BCE. Yes?
Did you compare the change in takeover premium in Canada to the United States, the UK, or the other?
Oh, I'm sorry. You guys have been missing, it's the core of the talk. I'm very sorry. But you'll be lost for the next half hour. Okay. So you might go, all right, well, this is all very nice economic, statistical stuff. What about actual life in the boardroom? Well, the stuff that corporate lawyers do all day long. Surely BCE's had an effect in that. And here my answer again is no, it really hasn't. I'll give you two examples of it here in Canada. First of all, the first one is fairness opinions. Anytime a board of directors approves something like a takeover, almost any material transaction, they usually want something called a fairness opinion, which is given by an investment bank or more rarely an accounting firm. And what the opinion is the investment bank scrubs the deal, does a valuation of, in my view, marginal quality on the company, and then provides an opinion to the board of directors that says this transaction is fair from a financial point of view to the shareholders. That's why it's called a fairness opinion. What does a fairness opinion give you? Every Corporations Act in Canada says that directors are entitled to rely on the opinion of an expert. And so the fairness opinion, provided it's not complete balderdash, can be depended on by directors if they're ever sued. So it's a form of insurance / director cowardice. And you pay insurance like rates. You pay hundreds of thousands of dollars to have an iBank give you this fairness opinion. It is not an insignificant thing, it's expensive. And so you might ask, well, didn't BCE say that actually transactions have to be fair to other parties than shareholders? Surely this affected the practice of fairness opinions. No, it did not. Fairness opinions continue to be used in every transaction, and they have exactly the same terminology, fair from a financial point of view to the shareholders. The second area of legal practice I want to touch on is fiduciary out clauses. So most takeovers in Canada, the United States, the UK are friendly. I think the number in the US is about 86% of takeovers are friendly. And usually what happens is they enter into the target company and the company being acquired enter into something called a support agreement, where the target says, look, we'll make a bid to buy all the shares of the company at this price. And the target company's board of directors says, well, obviously we can't guarantee what the shareholders are going to do, but we will do our best to bring the shareholders on board. And in particular, we will recommend the shareholders tender to the bid. That's the support agreement. There have been case law, and usually support agreement also says that the target company, in particular its board of directors and managers, will not solicit additional bids. The bidder is saying, look, we are spending a ton of money on lawyers and investment bankers. We are paying millions of dollars in standby fees from the banks or other creditors who are going to lend us the money to acquire the business. We don't want to spend all this time and money if you guys are just taking our deal and shopping it to other purchasers. So we want you to run your auction beforehand. If we're the winner of the auction, we want you to say you will not solicit new offers. In fact, we would like you to say, ideally, you're locked in. You will not consider new offers. So those provisions were put into agreements about 30 or 40 years ago in the United States. And the courts found that if the directors agreed to lock in to a bid, that fettered their discretion. And therefore, those provisions were void for public policy. The court said, look, the director's duty is to maximize shareholder value. They have to be free. If a better bid comes in, they have to be free to recommend a better bid. And any provision that bars them from doing so, we're just going to excise from the contract. It will be unenforceable. And that created a need for something called a fiduciary out clause. This is when you go work in law firms, this will be what it's called. The fiduciary out clause says you will not solicit a better bid unless a better bid comes in the door. Usually the terminology in Canada is superior bid, superior bid. So UBC's own Camden Hutchins very kindly did the research looking at, I think, over 1,000 support agreements to find out, did the fiduciary out clause change after BCE? what counts as a superior bid? Could that include a better bid for employees or a better bid for the environment? Or is the fiduciary out only limited to a more valuable bid for the shareholders? And what he found was that only one agreement out of the 1,000 agreements contained a reference to anyone other than shareholders. Another instance where legal practice apparently is unchanged. By the way, the one bid that did include a reference to stakeholders was the London Stock Exchange's acquisition of the Toronto Stock Exchange, which was a politically very fraught transaction with the securities regulators, and I know this because I was involved with two of them, very panicked about the idea that Canada might lose its stock exchange to a UK acquirer. And so they had a fiduciary out that included stakeholders. It wasn't a normal corporate transaction. It was a weird transaction. Anyways, that's the only one that's happened. Okay, so what can we say in summary about Canada? BCE decision happens, transforms the fiduciary duty. Nothing visible happens in terms of economics. Nothing visible happens in terms of legal practice. You might say, well, that's just Canada, we're weird. But the same thing happened in the United States, though it happened a little differently in the United States. Corporate law is a matter of state law in the US, and that means that every state gets to set its own rules. Beginning in the 1980s, when the takeovers, especially leveraged buyouts, really started to cook, states started getting nervous about losing big state champions. So they started started introducing various laws that were designed to resist corporate raiders or facilitate white knights. So they could keep, for example, Dow Chemicals in Ohio. They don't want Dow Chemicals to be run out of New York. Ohio likes Dow Chemicals, employs lots of people. It provides a ready audience for country clubs and golf courses. They don't want to lose those people. So they would bring in these, they're called constituency statutes. These constituency statutes would say, look, directors, exactly what BCE says, directors in most cases have the option of considering stakeholders, non-shareholder constituencies, and a few states brought in, no, they've got a duty to consider their impact on the communities they're in and the employees that they have. So what happened when Americans, and whereas we couldn't run controls in Canada, you can run controls in America, because just Ohio is bringing in this in the statute. So you can look at what happens in other states and compare what's happening in Ohio when that happens. So this is what the research found. So first of all, they found it makes no difference in litigation. So constituency statutes, which everyone thought were going to be, I think a very famous academic named Stephen Bainbridge said the most consequential amendment in corporate law history since the invention of the modern corporation statute in the late 19th century America. Turned out it's had almost zero footprint in litigation, American litigation. And Americans love suing each other. It's just, they love it. I don't understand it. And so to have virtually no footprint, that's really saying something. Canada, we don't sue each other so much. In the US, the fact that constituency statutes don't seem to play much of a role in the frequent lawsuits, it's kind of amazing. We found, looking at 14,000 companies over a 25-year period, scholars found that very few of those companies actually moved from a shareholder primacy jurisdiction to a constituency jurisdiction or the other direction. And keep in mind, one of the big worries is that if we give managers the ability to blow off a single focused goal on shareholders, they're going to run amok, because a duty to anybody is a duty to nobody. They actually found that less than 0.1% of American companies moved from a shareholder jurisdiction to a stakeholder jurisdiction, even though that would, in theory, mean the directors were completely liberated of their fiduciary duty in this practical matter. Constituency, they found that constituency statutes don't impact the rate of hostile takeovers. which is the whole reason for having constituency statute. You're just as likely to get taken over in a constituency state as you are outside the constituency state. Shareholders complained about constituency statutes when they came in. There was lots of chest beating. Shareholders, we deserve to be the ultimate beneficiary of corporate operations. But as it turns out, did they sell the shares of companies in constituency jurisdictions? They did not. Their portfolios remained unchanged. They complained a lot about it, but their trading decisions went on as if these things didn't matter at all. A very familiar, if you study corporate governance, very familiar phenomenon. And then finally, they looked at event studies. What happened to the value of companies? Again, this is the same question my co-author and I asked about BCE. If a company is suddenly relieved of its duty to maximize shareholder value, you'd expect if that duty matters at all, keep in mind this is the central duty of corporate law, you'd expect the price of those shares to go down as shareholders start factoring in the risk that someone else's interests are going to be considered. And what we find is the constituency statutes either had at least 3 event studies that had no impact at all, or they had a very tiny impact, 0.03%, that dissipated within days. In other words, there's no evidence the value of these companies were affected by changing the most fundamental duty of corporate law. Okay. And then some other studies, more recent, look at things like, do employees get paid more in a constituency statute? No. American scholars have also looked at legal practice. So they look, for example, at private equity deals where the PE fund buys out a public company. These deals get negotiated. They are among the most complex and sophisticated in corporate law. Everyone is lawyered up out the yazoo. These are not blow-off non-disclosure agreements issued by a software startup that's 6 months old. These are the chef's kiss of legal agreements. And they look at these to see, is there any evidence at all that companies based in constituency jurisdictions are bargaining on behalf of employees or the environment or the communities in which they run factories? And just like we found the fiduciary out clauses, or Camden found fiduciary out clauses or fairness opinions, we find no evidence that they are. And where something like employees or communities are mentioned, there's no basis in those agreements for these obligations for the buyer to be enforceable. So they're clearly just, whitewashing. Okay. So that's a situation. The most important duty in corporate law, the duty that says what are corporations, what's the purpose of a corporation, for whose benefit is a corporation being run, has had no impact. So I want to talk about a couple possible explanations. We're done, 5 more minutes. So some scholars have said, look, the problem is executive compensation. Managers, CEOs are loaded up with stock or stock options or deferred share grants or some other equity incentive scheme. And so these things pay out like a broken slot if a takeover happens or if the company really manages to increase its share price. And so that's the problem. Of course, management's going to act in accordance with its own interests, and its own interests are to maximize shareholder value. There are a couple problems with this. The first is equity incentives did not really exist as part of executive pay packages in the United States until the 1990s. For most of the periods after the Second World War, American executives got paid with salary and a bonus. And so you wind up having, there's no evidence that directors and officers were ignoring shareholder value or profit-making activities before this revolution in executive compensation. The other factor is that boards typically reprice options and equity grants if they fall out of the money. Shareholders hate that, but it's too bad. You just wind up doing it. So even if the share price doesn't really go up, we find a way for the stock options or shares of an executive to payout. We can get an argument about the right doing that, but that's very common. The third thing is that managers themselves say incentive pay doesn't affect their behavior. I have a couple papers, which I won't bother going into unless people are really interested, in which I suggest that managers aren't lying about this. There's very little evidence that incentive pay or pay for performance, or any of the pay schemes that we use to incentivize wealth creation actually have an impact on managerial behavior, and actually a reasonable amount of evidence that it makes their behavior worse. Finally, the final point I want to make about director and officer compensation is it's not actually up to the CEO whether or not a company gets sold, for example, or merges, or engages in some major transaction. For the last 30 years, we've handed those decisions off to committees called special committees comprised entirely of independent directors. And independent directors are not loaded up with equity. They've got some. It's not a payday for them, but it is a small payday. It's not enough, by design, it's not enough to twist their decisions in one direction or another. It's supposed to keep them neutral. So that's the first argument that's made, and I don't find it convincing. The second argument that's made about why constituency statutes or the BC case has made no difference is shareholders' control rights. As we know, shareholders elect directors. And so no less an authority than the great ex-chancellor of Delaware, Leo Stride, has said, look, as long as shareholders are in charge of electing directors, we should not expect directors to do anything but work on behalf of the shareholders. They're not going to suddenly start working against the interests of their bosses. I don't find this convincing either. I don't find it convincing because, first of all, as I again show in several papers, and in fact an entire book that's coming out in June from Cambridge, shareholders both lack the incentives and the resources to vote in their own interests. There's lots of evidence that shareholder voting either doesn't happen at all, or if it does happen, it's not a function of economic performance. To give you an idea of how bad shareholders are as a real disciplining mechanism, in a typical year, there are about 31,000 directors up for election in America. A few years ago, which I think a typical year, I just picked it kind of at random when I was writing a paper, 8,000, I apologize. There's 31,000 directors up for election, 8 directors were voted against. 8. I can guarantee you the other 992 directors are not living in fear of the shareholder franchise. The empirical evidence is huge that shareholders do not vote based on financial performance of the company. So the most recent study found that a standard deviation in EBITDA to assets, so that's basically earnings to assets, profits to assets. It's not quite that, but for the benefit of this is basically what it means. That a standard deviation, that is a whole movement statistically. This is a terrible thing. This is a catastrophic event relative to the industry peers, results in a 0.37% reduction in director support. So if you absolutely whiff it relative to your peers, you will lose 0.37% of the support you would have expected and still be elected with about a 92-93% vote in favor. I just don't see any evidence in the shareholder franchise that this is a real threat. And I can tell you most directors don't spend a lot of time wringing their hands about it. Some of them spend a lot of time in boardrooms. So what do I think explains the fact that the most important duty in corporate law has no effect on what corporations do? I think that we've forgotten the most important part, and the Supreme Court probably never understood the most important thing about corporations, and that is they're business corporations. It's right there in the name of the acts, the Business Corporations Act, British Columbia, the Alberta Business Corporations Act. Business means these companies, for the most part, not all of them, but nearly all of them, compete in highly competitive markets. Not just the market for the products and services they sell, but the markets in which they buy from suppliers, the markets in which they source credit, the markets in which they hire and fire employees. And that doesn't actually mean that what that means is management doesn't have a lot of slack. They don't have a lot of alternatives except to pursue profit-making activities vigorously. If you've been inside a corporation, you realize that a fraction of 1% is the amount of time they spend thinking about corporate governance and agency costs. And the other 99% plus of the time, they think about how to compete in the markets. They are worried much more about going out of business than they are about losing a shareholder vote. And in a competitive market, it's very hard to make money. People who have not been in business don't understand that. But you have to work very, very hard not to go the way they do. There are exceptions, like Canada's banks, but they're pretty far and few between. So I don't think directors have any choice except to work on profit-making activities. And if the shareholders are the ultimate beneficiary of that profit-making activity, that's the way it is. That's the way the system's set up. They're the economic residuary holder. If the company doesn't make profits, the shareholders are the ones who take it on the chin, long before the employees and creditors do. So they also get meant for the upside. I would also point out, just in passing, that corporate companies, one of the markets companies also compete in, besides products and services, is capital. Because equity is at the base of the pyramid and it supports every other creditor of the company, which includes employees, it includes the taxing authority, it includes everybody else who's got a fixed claim on the company. They're the highest risk investor. That means they're almost always the hardest investor to get in. That is always going to trump whatever you say the legal duty is. The shareholders, you have to convince the shareholders you care about them. If they don't come in, nothing else happens in the corporation. You can't borrow money without equity lying underneath it. So that's my answer. The Supreme Court of Canada made a dumb decision, fundamentally changed the rules of the game. That change made no difference because everyone, including the Supreme Court, forgot that companies compete in markets. I think that's it. That's what I wanted to say here today.
Thank you very much.
Any questions?
Q&A, if you want to ask a question without being recorded, you can just mute it. And for those online, if they want to ask a question, maybe they can send it to you directly, and you can ask it on their behalf.
I've been muting stuff inadvertently already, so actually consciously, I'll be awesome.
Just let us know if you want it to be muted.
Yes.
Yeah, so I'm coming from a place of ignorance, so if I'm misunderstanding the terms, please clarify. But from what you described of BCE, it sounds like a particularly weak form of stakeholder requirements, just to consider the impact on the debt holders, even if you don't act in their interest.
Well, of course, someplace they say it's an obligation, so you must consider. But probably, I mean, as I say, it's not a very well-written decision. Probably, given the result, all you have to do is consider it, right? Turn your mind to it. But yeah.
So isn't that in line with kind of a requirement to follow the shareholder interest? Because as a business, you got to consider like long-term profitability, right? So if you're screwing over your debt holders, that might impact your ability to raise debt in the future. Even if you don't act in their interest, you should probably consider how it's going to affect them, right? Right.
The best way to think about it is not, and looks frequently BC and other decisions like this, or this whole issue is discussed in terms of motivation. I don't think it's a very useful way to discuss it, because when you look at the decisions a management team makes, obviously some of them are going to benefit the employees, right? You can't have your best people leaving to other businesses. So you're going to have to think, do we need to pay bonuses this year? What's the morale like? And that money is going to come out of the profit pot, away from the shareholders, and go to the employees. So every decision, and sometimes you will take on debt with high interest rates, but you need to build something, that also come up. So in terms of motivation, decisions all the time are made to benefit some other constituency than the shareholders. I think the better way to look at it is an economic way, which is every decision management makes is in a way an investment that's going to generate a return. And the question is, are they making investments with the highest net present value possible? That is an investment to pay the employees more that is going to generate a higher net present value than, for example, giving that money to the shareholders and not paying the employees more. And so if you look at it from an economic standpoint, what the stakeholders, the people who are pro-stakeholder want to do is they want companies to make investment decisions with a lower net present value than the alternatives. And those are decisions that ultimately are designed to benefit the employee and not just in helping the employees to maximize profits and therefore shareholder return. So if you look at it from the economic standpoint, I find it very clarifying anyways about what exactly the debate is about in practice rather than the motivation. That kind of helped.
That clarifies things.
Yeah, and it's a good question. And I find even legal scholars who should know better often spend their time talking about motivation as if that matters. The truth is, managers always care about their employees, so they always care about their creditors. You have to. Your whole goal is to assemble this productive coalition and keep it happily working together to get the outcomes you want, to make profits. Any other questions? Yes.
Yeah, there's two online. The first one is, can you please let us know the name of the paper on that case that was referred to earlier?
Oh, is my paper on BCE?
That's all the text there, so I'm not sure the context.
All right. Well, it sounds sort of vain that I assume that was the paper they're interested in. So the name of the paper I wrote, and they can clarify if it's a different paper. It's Bryce Tingle and Eldon Spackman. It's my co-author. To the extent it has math, I can assure you Eldon Spackman did the math. And it's called Do Corporate Fiduciary Duties Matter?
And the second is more of a comment. They said, the need for controls can't easily be dismissed. The easy way to do this is to construct a synthetic control group for Canadian companies.
If they know how, I'd be grateful for it. But the fact is, BCE changed the rules for every Canadian company all at the same time. And so Camden was right. The only real control that would be available would be either using the American or the UK as a control. And we spent a lot of time, including with finance scholars, looking at whether or not this would actually add light or a spurious confidence. And we concluded it was more likely to produce a spurious confidence. So we just said, we're better off just saying, well, this is an obvious limitation in our work. But we don't think it's going to impact it because the macro. And the macros really help us. If you lived in 2006, it was bloody wonderful in Canada's public markets, capital markets. It was just flowing cash. Every company's trading at the top. And it has been quite bad off and on since. And certainly we haven't seen the commodity prices that we saw in the run. So the macro suggests that if there is an effect, it's very muted from, possibly conflating trends.
We had another one coming online. Do you think the rise of DEI has impacted how corporate executives focus their time? In other words, is this taking away from time spent on increasing corporate earnings?
Right, yeah, it's a good question. So there is a personal and a political aspect to DEI. I don't want to get into the political aspect of DEI. I mean, I'm not an expert on it anyways. So whether or not focusing on gender and racial differences and trying to hit targets or quotas or wherever you fall in terms of on the spectrum in terms of your policy outcome, your policy mechanisms. Maybe it works, maybe it doesn't. But on a personal level, DEI tends to have a pretty corrosive effect in the institutions where it's in. Because people feel like they need to feel like they're treated fairly. That if they're the best person for the job, they've been promoted. And someone didn't get promoted because they belonged to a underrepresented racial or gender or sexual minority, right? And we've seen lots and lots of institutions, including universities, that have brought in DEI very highly. We've seen them descend into a high level of dysfunction as a result. So my sense is, and this is not James Gosser, my sense is most executives genuinely want to see improvements in representation of gender and racial and sexual minorities. I find them generally, as I spend time with them, progressive in those ways. But they're very reluctant to bring in the more self-conscious and heavy-handed kinds of DEI programs because of the possibility of creating ill will in an organization requires a lot of cooperation and trust in order to work. So that's a partial answer to the question. Another element is there have been some areas where I think DEI has made obvious progress, I guess you could say. That is the gender composition of boards, which we've been working on since 2010, kind of in a self-conscious way. Though, I mean, obviously it was an issue for long before. But we brought in, Ontario brought in a diversity disclosure requirements in 2012, I think. Since then, the percentage of directors who are women has gone up. Not a lot, doesn't satisfy many of the women who are working in this area, but it's gone up. What has not much changed is diversity in the actual line positions of the corporation, so CEOs, CFOs. I mean, some areas it hasn't gone up. Even in 2012, I think something like 2/3 of the general counsel of TSX 100 companies were women. So there were some areas where we had plenty of gender diversity. But CEOs is usually the thing people really look at. We haven't seen a lot of movement in that. In fact, there was a Wall Street Journal article that just came out yesterday that seen that in the United States, the number of female senior executives has actually gone down in the last few years. I think this is a function of precisely this political, personal thing. I don't think it's a sign that these people running these companies don't care about it. I think it's that they kind of feel they feel pressure to put the best person in that they think they can. And they worry about making ostensibly following DEI targets that impact on other managers and on employee morale and the rest of it. But it's not an area I work a lot in. I just know the major trends. Yeah.
I just wanted to add to that. I didn't mention in the beginning that we have a podcast called Curious Task, which you should all listen to. But just last week, we had an episode with Akshaya Kamalnath, and she did a whole episode on does corporate diversity work? And she did research not just in Canada and the United States, but all around the world on this. So I really recommend that you listen to that episode if you're interested in that aspect of corporations.
I can tell you that DEI mentions, so they use machine learning to go through the transcripts of earnings calls. So if you know what an earnings call is, every quarter company issues its financial statements, and then it gets on the phone, mostly with the analysts that follow the corporation to explain the financial results and answer questions from the analysts and even some of their large shareholders. It's called an earnings call. They're all recorded and transcripts are made of. And you can send machine learning, sort of an AI, to go in and scrape all these transcripts to see what words are being used. And so one thing that's been reported on in the press is the number of mentions of DEI has been trending downwards. I think because corporations don't like controversy in DEI, especially in the United States, it's become way more controversial. So whether or not they're doing the same things under a different name, whether or not they're right or wrong, outside of probably this talk to get into, but yeah, there's less, they're avoiding at least mentioning DEI to their shareholders, which is telling.
There's another one online.
Sure.
Have you examined this issue in jurisdictions outside of North America? For example, in Germany, companies with 2,000 plus employees are required to have separate management and supervisory boards where half the members of the supervisory boards are elected by the employees. presumably this dilutes management's focus on profit maximization, but maybe they don't care.
Yeah, it's a good point. It's an outstanding question. It's not just Germany. Most Northern European countries have the same rules. So there are a number of studies as you'd expect. And the studies up to about, I would say, 10 years ago, all found that companies that had employees on the board, on the supervisory board, paid their employees more and were less likely to fire employees than matched peer firms. In the last 10 years, though, people have gone back with, I think, with better design studies. They are better design studies. And in particular, they've tried to control for the size of the company and whether or not the company is unionized. Once they control for those two factors, they find that putting employees on the board has no impact. And there's at least 3 or maybe 4 studies in different countries, different data sets that find exactly the same thing. And for those who want to change the world through corporate governance, like maybe the Supreme Court does, that is really sobering, right? That is the single most powerful thing you can do, which is put an actual constituency on the board. And if that's having no impact, then that really should cause you to reconsider whether or not you're going to get anything out of a company except profit-seeking behavior. There also have been studies looking at, from the United States, looking at labor funds. So unions have pensions, and those pensions get invested in the stock market. So they look at the behavior of these labor funds as shareholders. And the researchers who looked at it, I think the best summary of the research provided by the most recent study, which is basically like, these labor funds are a model of a profit-seeking investor. There's no real impact, nor do they really appear to try to have an impact on the behavior of the board of directors. And again, that's a very consequential. You're looking at, what happens when the employees actually become owners of the company. And it appears they behave just like every other shareholder. They want to maximize the returns. That's a great question. Yeah.
So I have so many questions that I could ask, but I will just stick to one. So my question is, you mentioned, I quite agree with your thesis, but you mentioned that this has not changed boardroom practice at all, but then your evidence for the lack of change in boardroom practice was really more to do with outcomes rather than like a qualitative description of what boards are actually doing. So my question is, as somebody who's not, I have not practiced in Canada. I've certainly not sat on corporate boards in Canada or anywhere else. Are boards though, are they being advised by their legal counsel, like boards of big public companies, like, look, you need to at least establish some kind of record that you're considering different constituents when you're facing a takeover, you're making up some other kind of significant corporate transaction. Like, are they literally ignoring the suggestion from BCE, or are they doing what the Supreme Court sort of asked them to do, which is like, you have an obligation to consider these groups, but you don't have an obligation to do anything?
Right, so let's talk about takeovers specifically, because I know that. So I chair right now 3 corporate boards. I'm on, I've been on about 15 or 20 corporate boards over the last decade and a half, and advised a bunch of them. So I feel like I've kind of got a feeling, but nevertheless, it's anecdotal, and other people may have different experiences. So in a takeover, what happens is you create a special committee comprised of independent directors. Management is seen to be conflicted in a takeover because they're either getting fired or they're getting paid an enormous amount to stick around. Either one compromises their decision making. So you give it to the independent directors. The first move is they hire their own lawyer. And so the key moment is when they meet separately away from management with their own lawyer. And what happens in that meeting is their own lawyer will always rehearse, in my experience, the BCE decision. And will say, so your duty is not just to maximize shareholder value, it is consider the other stakeholders in the company. That out of the way, what then ensues is maximizing shareholder value.
That's pretty much what I would. So there's kind of like a pro forma recital of BCE, and then now let's get down to business.
That's exactly right. In exactly the same way that the testimony of BCE was, the special committee had heard from, I think it was Stykes was on BCE, had heard from their lawyer, your duty is to maximize shareholder value. That was in testimony at trial on the BCE decision. Now it's just changed to your duty is to the corporation, which involves you need to consider all the constituencies. Yeah.
But no, in your, I guess maybe it's a bit anecdotal, but in your personal experience, no meaningful engagement with stakeholder issues.
Yeah, I mean, in my personal, yes, in my personal experience, yeah, no meaningful engagement. I mean, there always has been concern, for example, with employees. So not so much if you're dealing with a copper mine or a oil well, when you don't really care about the humans. But any tech or industrial company, an enormous amount of the value is in walking around inside people's heads. And so usually your priority in an acquisition is to ensure that people stick around. And so you often find deals with retention bonuses, with incentive programs to stick around. You often have as a condition in a support agreement that the bidder has to successfully get people to sign contracts going forward. So you find a great deal of effort, for example, around some constituencies to keep them. Where there's a major supplier or a major creditor or a major customer, you will often find support agreements requirements that they're on board and approve this as well. Like that would be a condition of making the bid. We'll make this bid if your major supplier agrees that this is okay and enters into agreements on the usual terms with the resulting entity. So there's always those sorts of things, and always have been. Just it's necessary to run a business. But no, nothing beyond that. I've noticed no change in the tenor of boardroom conversations since BCE, in my limited experience. All right, well, thank you very much for having me. It's been a great pleasure talking about these things.